Welcome to this explainer. Today, we are diving into one of the absolute most fascinating, high-stakes arenas in all of healthcare, the intersection of law and medical ethics. And listen, this isn't just some abstract theory. It's a daily reality where human lives, personal morals, and incredibly strict regulations collide head-on.
Now think about this for a second. What actually happens when your moral duty to care for someone clashes directly with the law? Or what about when a patient makes a decision that you know for a fact will harm them, but you are legally bound to respect it? In healthcare, conflicts like these are completely inevitable. And knowing exactly how to handle these legal conflicts is really what separates everyday practice from true legally protected patient advocacy.
Okay, let's dive into this. Think of today's outline as your personal shield and compass survival guide. We're going to cover 1. Ethics and law convergence. 2. Guiding ethical principles. 3. The legal framework. 4. Patient rights and consent. And finally, 5. Managing legal conflicts.
Starting off with Section 1, Ethics and Law Convergence. It's kind of like a professional's brain is split right down the middle. On one side, we have our ethical foundations, right? That's your moral compass of right and wrong. On the other side, you've got the legal framework, the strict regulatory structure that actually defines the scope of practice. But that sweet spot right in the middle, that convergence is where ethical principles and the law combine to truly protect patient welfare. You really can't have one without the other.
Moving right along to Section 2, Guiding Ethical Principles.
And this brilliantly illustrates what happens when those guiding principles literally go to war with each other. An ethical dilemma occurs when two entirely right actions conflict. The classic example here is beneficence, which is the duty to do good, versus autonomy, the patient's right to choose. Imagine a scenario where a patient's religion, let's say a Jehovah's Witness, strictly forbids receiving blood products, but they desperately need a transfusion to survive. As a provider, your instinct is to heal, for sure, but the golden rule is that the practitioner's priority is always to honor the client's wishes. When a competent patient says no, their autonomy overrides beneficence every single time.
So when you hit a wall like that, having a system to handle the conflict is absolutely crucial. This 6-step ethical decision-making process acts as a roadmap so we don't just guess. We systematically identify the problem and gather the relevant information, like checking if there's a legal advance directive in place. The massive key takeaway here is Step 3. We have to ensure our own personal beliefs aren't secretly driving the medical decision. From there, we consider the options, take action to advocate for the client, and finally, evaluate the outcome. It's structured, it's objective, and it keeps your practice grounded.
All right, Section 3, the legal framework.
We basically have two massive pillars building out our professional defense, acting as a legal shield. First is a state's Nurse Practice Act, which is the literal law. It dictates education requirements, scope of practice, and the exact grounds for discipline. The second pillar is the standards of care, which are the guidelines for what safe, quality nursing actually looks like. Together, these are your golden rules for professional survival. In a courtroom, a practitioner is judged against these very standards, making them the ultimate way to handle conflicts and protect against a malpractice lawsuit.
But, what happens when someone breaks those rules? Well, state boards of nursing do not mess around. They can instantly deny, revoke, or suspend a license. If we rapidly run through the common reasons for disciplinary action, we're looking at unprofessional conduct, doing anything that harms public safety, breaching client confidentiality, and acting with insufficient knowledge. It also includes any form of abuse, taking on duties without proper training, unsafe delegation, falsifying records, or abandoning an assignment. The common thread is crystal clear. They all directly relate to safety, competence, and professional conduct.
Which brings us to the front line of conflict prevention in Section 4, Patient Rights and Consent.
It is really fascinating to contrast these two concepts. With informed consent, it is explicitly the provider's job, so the doctor, the NP, or the PA, to explain the risks, benefits, and alternatives of a procedure. The nurse's role is simply to act as a witness, confirming the patient is competent and signing voluntarily. However, when we look at a patient's right to refuse, a competent adult has the absolute, undeniable right to withdraw consent at any time, even after they've signed the paperwork. They can leave against medical advice, or AMA, and you literally cannot force them to stay. Your legal duty there is to explain the risks of leaving, document the discussion flawlessly, and safely remove any invasive devices before they walk out the door.
Let's move into our final section, Section 5, Managing Legal Conflicts.
So the crucial point here is that understanding the intent behind a wrongful act is step one in actually handling a legal conflict. Intentional torts are willful. We're talking about assault for threatening a patient, battery for giving an injection they refused, or false imprisonment for physically blocking someone from leaving AMA. On the flip side, unintentional torts involve accidental harm, like negligence or malpractice, say accidentally failing to check a medication label. Both of these can absolutely lead to lawsuits, but knowing exactly which legal line is being crossed helps practitioners rapidly de-escalate the situation, manage the conflict, and document everything appropriately.
Now, another massive area where legal conflicts pop up is staffing. When you're faced with dangerously understaffed units, it's a huge problem. But you can't just leave. That is legally considered abandonment. The right way to handle this conflict is by strictly following your chain of command and officially reporting the unsafe conditions. Similarly, if you're asked to float to a totally unfamiliar unit, the primary tool for handling that dispute is referencing your facility policy and making sure client safety is the priority. The only real exceptions are if a union contract specifically protects against floating, or if there's clear proof you lack the basic skills to provide safe care there.
Finally, in some legal conflicts, the law just entirely removes the gray area and forces your hand. Handling these specific situations means recognizing your absolute duty as a mandatory reporter. We're talking non-negotiable situations like suspected abuse of vulnerable populations, impaired coworkers, direct threats of harm, specific communicable diseases like HIV or TB, or injuries from criminal activity like gunshots or stabbings. Failing to report these doesn't just make a practitioner ethically complicit, it guarantees severe legal fallout and major disciplinary action against their license.
Wow, we have covered a tremendous amount of ground today. And really, it all leads to this final thought. In a healthcare system built on both incredibly rigid laws and deep human compassion, are you prepared to be the ultimate advocate for your patient? By truly understanding this legal framework and keeping a clear ethical focus, you are empowered to navigate and handle these legal conflicts confidently, all while protecting the most vulnerable. Thanks so much for exploring this with me today, and I'll see you next time.